Act 29. Part 2. Chapter 1. Section 30. Justification for force or harm. 1. For the purposes of this act, force or harm is justifiable which is used or caused in pursuance of a matter of justification, and within the limits that are provided for in this chapter. 2. In the remainder of this chapter, expressions applying to the use of force apply also to the causing of harm, although force only may be expressly mentioned. Section 31. Grounds on which force or harm is justified. Force may be justified in the case and in the manner, and subject to the conditions provided for in this chapter, on the grounds a. Of express authority given by an enactment, or b. Of authority to execute the lawful sentence or order of a court, or c. Of the authority of an officer to keep the peace or of a court to preserve order, or d. Of an authority to arrest and detain for felony, or e. Of an authority to arrest, detain, or search a person otherwise than for felony, or f. Of a necessity for the prevention of or defense against a criminal offense, or g. Of a necessity for defense of property or possession or for overcoming the obstruction to the exercise of lawful rights, or h. Of a necessity for preserving order on board a vessel, or 1. Of an authority to correct a child, servant, or other similar person, for misconduct, or j. Of the consent of the person against whom the force is used. Section 32. General limits of justifiable force or harm. Although there may exist a matter of justification for its use, force cannot be justified as having been used in pursuance of that matter. A. Which is in excess of the limits prescribed in the section of this chapter relating to that matter, or b. Which extends beyond the amount and kind of force reasonably necessary for the purpose for which force is permitted to be used. Section 33. Use of force under authority of an enactment. A person who is authorized by an enactment to use force may justify the use of necessary force, according to the terms and conditions of that authority. Section 34. Execution of sentence or order of a court. A person who is authorized to execute a lawful sentence or order of a court may justify the force mentioned in the sentence or order. Section 35. Use of force for preservation of order. A person who is authorized as a peace officer, or in a judicial or an official capacity, to keep the peace, or preserve order at any place, or to remove or exclude a person from a place, or to sue force for a similar purpose, may justify the execution of that authority by a necessary force. Section 36. Use of force for arrest, detention, or recapture. 1. A person who by law may, with or without a warrant or any other legal process, arrest and detain another person. A. May use force which is necessary for the arrest, detention, or recapture of that person, and b. May, if the arrest is made in respect of a felony, kill the other person, if the other person cannot by any means otherwise be arrested, detained, or retaken. 2. Force may be used under subsection 1 only where the other person, having notice or believing in the lawful arrest, avoids arrest by resistance or fight, or escapes or endeavors to escape from custody. Section 37. Use of force for prevention of, or defense against, criminal offense. For the prevention of, or for personal defense, or the defense of any other person against a criminal offense, or for the suppression or dispersion of a riotous or an unlawful assembly, a person may justify the use of force or harm which is reasonably necessary, extending in case of extreme necessity even to killing. Section 38. Unlawful fights. 1. A force used in an unlawful fight cannot be justified under a provision of this Act. 2. A fight is an unlawful fight in which a person engages, or maintains, otherwise than solely in Pursuance of a matter of justification specified in this chapter. Section 39. Use of force for defense of property or possession. A person may justify the use of force for the defense of property or possession, or for overcoming a obstruction to the exercise of a legal right, where a person in actual possession of a house, land or vessel, or goods, or the servant of that person or any other person authorized by that person, may use force that is reasonably necessary for repelling a person who attempts forcibly and unlawfully to enter the house, land, or vessel, or to take possession of the goods. b. A person in actual possession of a house, land, or vessel, or the servant of that person or any other person authorized by that person may use force that is reasonably necessary for removing a person who, being in or on the house, land, or vessel, and having been lawfully required to depart from that place refuses to depart. c. A person wrongfully takes possession of or detains goods, any other person who, as against the first mentioned person has a present right to the possession of them, may, upon refusal to deliver up the goods on demand, use force, personally or by any other person, as is reasonably necessary for recovering possession of the goods, and d. A person may use force that is reasonably necessary for overcoming an obstruction or a resistance to the exercise by that person of a legal right. Section 40. Use of force for preserving order on board a vessel. 1. The master of a vessel, or a person acting by the order of the master, may justify the use of force against any other person on board the vessel. a. That is necessary for suppressing a mutiny or disorder on board the vessel, whether among officers, seamen, or passengers, by which the safety of the vessel, or of a person in the vessel, or about to enter or quitting it, is likely to be endangered, or b. Where the master is threatened to be subject to the commands of any other person. 2. For the purposes of subsection 1, the master or the person acting under the order of the master may kill a person who commits or abets a mutiny or disorder, if the safety of the vessel, or the preservation of a person, cannot by any means be otherwise secured. Section 41. Use of force for misconduct. 1. A blow or other force may be justified for the purpose of correction, where a father or mother may correct his or her child, who is under 16 years of age, or a guardian, or a person acting as a guardian, the ward, who is under 16 years of age, for misconduct or disobedience to a lawful command. b. A master may correct a servant or apprentice, who is under 16 years of age, for misconduct or default in the discharge of a duty as a servant or apprentice. c. Repealed. d. A father or mother or guardian, or a person acting as a guardian of a child may delegate to any other person whom any of them entrust, permanently or temporarily, with the governance or custody of the child, or ward the authority of any of them for correction, including the power to determine in what cases correction ought to be inflicted, and the delegation shall be presumed, except where it is expressly withheld, in the case of a schoolmaster, or a person acting as a schoolmaster, in respect of a child or ward. e. A person who is authorized to inflict correction as in this section mentioned may, in a particular case, delegate to a fit person the infliction of the correction. 2. A correction cannot be justified which is unreasonable in kind or in degree considering the age and physical and mental condition of the person on whom it is inflicted. 3. A correction cannot be justified in the case of a person who, by reason of tender years or otherwise, is incapable of understanding the purpose for which it is inflicted.
Section 42. Use of force in case of consent. The use of force against the person may be justified on the ground of consent, but a. The killing of a person cannot be justified on the ground of consent. b. A wound or grievous harm cannot be justified on the grounds of consent, unless the consent is given, and the wound or harm is caused, in good faith, for the purposes or in the course of medical or surgical treatment. C. Consent to the use of force for the purpose of medical or surgical treatment does not extend to an improper or a negligent treatment. D. Consent to the use of force against a person for purposes of medical or surgical treatment, or otherwise for the benefit of that person may be given against the will of that person by the father or mother or guardian or a person acting as the guardian, if that person is under 18 years of age, or by a person lawfully having the custody of that person if that person is insane or is a prisoner in a prison or reformatory, and, when so given, cannot be revoked by that person. E. Where a person is intoxicated or insensible, or is from a cause unable to give or withhold consent, force is justifiable which is used, in good faith and without negligence, for the purposes of medical or surgical treatment or otherwise for the benefit of that person, unless a person authorized by that person or by law to give or refuse consent descends from the use of that force. F. A party to a fight, whether lawful or unlawful, cannot justify, on the grounds of the consent of another party, force which that party uses with intent to cause harm to the other party. G. A person may revoke a consent which that party has given to the use of force against that person, and the consent when so revoked shall not have effect or justify force. Section 43. Use of force against a third person. A person who, in justifiably using force against another person, is obstructed or resisted by a third person, may use force against the third person, that is reasonably necessary for overcoming the obstruction or resistance, and may, if the obstruction or resistance amounts to a criminal offense or to abatement of a criminal offense, use force in accordance with this chapter with respect to the use of force in case of necessity for preventing a criminal offense. Section 44. Use of additional force for exercise of justifiable force. A person who is authorized to use force of a particular kind against a person may further use an additional force, where it is reasonably necessary for the execution of the authority. Section 45. Justification of person aiding another person in use of justifiable force. A person who aids another person in a justifiable use of force is justified to the same extent and under the conditions that the other person is justified. Chapter 2. Section 46. 9 as amended by ACT 1101. Murder. A person who commits murder is liable on conviction to life imprisonment. Section 47. Definition of murder. A person who intentionally causes the death of another person by an unlawful harm commits murder. Unless the murder is reduced to manslaughter by reason of an extreme provocation, or any other matter of partial excuse, as is mentioned in Section 52. Section 48. Attempt to commit murder. A person who attempts to commit murder commits a first-degree felony. Section 49. Amended by ACT 1101, attempt to commit murder by convict. A person who, being under sentence of imprisonment for 3 years or more, attempts to commit murder is liable on conviction to life imprisonment. Section 49A. Amended by ACT 1101. Genocide. 1. A person who commits genocide is liable on conviction to life imprisonment. 2. A person commits genocide where, with intent to destroy, in whole or in part, any national, ethical, racial or religious group, that person A. Kills members of the group. B. Causes serious bodily or mental harm to members of the group. C. Deliberately inflicts on the group conditions of life calculated to bring its physical destruction, in whole or in part. D. Imposes measures intended to prevent births within the group. E. Forcibly transfers children of the group to another group. Section 50. Manslaughter. A person who commits manslaughter commits a first-degree felony. Section 51. Definition of manslaughter. A person who causes the death of another person by an unlawful harm commits manslaughter, but if the harm causing the death is caused by negligence, the person has not committed manslaughter unless the negligence amount to a reckless disregard for human life. Section 52. Intentional murder reduced to manslaughter. A person who intentionally causes the death of another person by unlawful harm commits manslaughter, and not murder or attempted murder, if that person a. was deprived of the power of self-control by an extreme provocation given by the other person, as is mentioned in sections 53, 54, 55 and 56, or b. was justified in causing harm to the other person, and in causing harm in excess of the harm which that person was justified in causing, that person acted from a terror of immediate death or grievous harm that in fact deprived that person for the time being of the power of self-control, or c. in causing the death, acted in the belief, in good faith and on reasonable grounds, of being under a legal duty to cause the death or to do the act which that person did, or d. being a woman, she caused the death of a child, which is a child under the age of 12 months, at a time when the balance of her mind was disturbed because she had not fully recovered from the effect of giving birth to the child or by reason of the effect of lactation consequent on the birth of the child. Section 53. Provocation. The following matters may amount to extreme provocation to one person to cause the death of another person, namely a. an unlawful assault and battery committed on the accused person by the other person, in an unlawful fight or otherwise, which is of a kind, in respect of its violence or by reason of accompanying words, gestures, or other circumstances of insult or aggravation, that is likely to deprive a person of ordinary character and in the circumstances in which the accused person was, of the power of self-control. b. The assumption by the other person, at the commencement of an unlawful fight, of an attitude manifesting an intention of instantly attacking the accused person with deadly or dangerous means or in a deadly manner. c. An act of adultery committed in the view of the accused person with or by the wife or the husband, or the criminal offense of unnatural carnal knowledge committed in the husband's or wife's view on the wife, or the husband, or child, and d. A violent assault and battery committed in the view or presence of the accused person on the wife, husband, or child, or parent, or on any other person who is in the presence and in the care or charge of the accused person. Section 54. Exclusion of benefit of provocation. 1. Despite proof on behalf of the accused person of a matter of extreme provocation, the criminal offense shall not be reduced to manslaughter if it appears a. that the accused person was not in fact deprived of the power of self-control by the provocation, or b. that the accused person acted wholly or partly from a previous intention to cause death or harm, or to engage in an unlawful fight, whether or not the accused person would have acted on that purpose at the time or in the manner in which the accused person did act but for the provocation, or c. that after provocation was given, and before the accused did the act which caused the harm, a time elapsed or circumstances occurred that an ordinary person might have recovered self-control, or d. that the accused person acted in a manner, in respect of the instrument or means used or of the cruel or other manner in which it was used, in which an ordinary person would not, under the circumstances, have been likely to act. 2. For the purposes of subsection 1, an ordinary person means an ordinary person of the community to which the accused belongs. 3. Where a person, in the course of a fight, uses a deadly or dangerous means against an adversary who has not used or commenced to use a deadly or dangerous means against that person, the accused person shall be presumed to have used the means from a previous intention to cause death, although before the actual use of the means, the accused person may have received a blow or hurt in the fight that might amount to extreme provocation. 4. Subsection 3 applies if it appears that the accused person intended or prepared to use those means before the accused person had received a blow or hurt in the fight that might be a sufficient provocation to use means of that kind. Section 55. Mistake as to matter of provocation. A lawful blow, arrest or any other violence may be a provocation, despite its lawfulness, if the accused person neither believed, nor, at the time of the act, had reasonable means of knowing or had reasonable ground for supposing that it was lawful. Section 56. Mistake as to person giving provocation. Where sufficient provocation is given to the accused person by one person, and the accused person kills another person under the belief, on reasonable grounds, that the provocation was given by that other person, the provocation is admissible for reducing the criminal offense to manslaughter in the same manner as if it had been given by the person killed, but it is not a provocation to kill a different person. Section 57. Abetment of suicide. 1. A person who abets the commission of a suicide commits a first-degree felony whether or not the suicide is actually committed. 2. A person who attempts to commit suicide commits a misdemeanor. Section 58. Abortion or miscarriage. 1. Subject to subsection 2. A woman who, with intent to cause abortion or miscarriage, administers to herself or consents to be administered to her a poison, drug or any other noxious thing or uses an instrument or any other means, or b. A person who 1. Administers to a woman a poison, drug or any other noxious thing or uses an instrument or any other means with the intent to cause abortion or miscarriage of that woman, whether or not that woman is pregnant or has given her consent. 2. Induces a woman to cause or consent to causing abortion or miscarriage. 3. Aids and abets a woman to cause abortion or miscarriage. 4. Attempts to cause abortion or miscarriage, or 5. Supplies or procures a poison, drug, an instrument or any other thing knowing that it is intended to be used or employed to cause abortion or miscarriage. Commits a criminal offense and is liable on conviction to a term of imprisonment not exceeding 5 years. 2. It is not a criminal offense under subsection 1 if an abortion or a miscarriage is caused in any of the circumstances referred to in paragraph A or B of subsection 1 by a registered medical practitioner specializing in gynecology or any other registered medical practitioner in a government hospital or in a private hospital or clinic registered under the Private Hospitals and Maternity Homes Act, 1958 and Number 9, or in a place approved for the purpose by legislative instruments made by the minister. A. Where the pregnancy is the result of rape, defilement of a female idiot or incest, and the abortion or miscarriage is requested by the victim or her next of kin or the person in loco parentis, if she lacks the capacity to make the request. B. Where the continuance of the pregnancy would involve risk to the life of the pregnant woman, or injury to her physical or mental health, and the woman consents to it, or if she lacks the capacity to give the consent, it is given on her behalf by her next to kin or the person in loco parentis, or C. Where there is substantial risk that if the child were born, it may suffer from, or later develop, a serious physical abnormality or disease. 3. A person who intentionally and unlawfully causes abortion or miscarriage commits a second-degree felony. 18. 4. For the purposes of this section, abortion or miscarriage means the premature expulsion or removal of conception from the uterus or womb before the period of gestation is completed. Section 64. Causing death. The general provisions of Part 1 with respect to causing an event are, in their application to the causing of death by harm, subject to the following explanations and modifications, namely: A. The death of a person is caused by harm, if by reason of the harm, death has happened. Otherwise or sooner, by however short a time, than it would probably have happened but for the harm. b. It is immaterial that the harm would not have caused the person's death but for the infancy, old age, disease, intoxication, or any other state of body or mind of that person at the time when the harm was caused. c. It is immaterial that the harm would not have caused the person's death but for the refusal or neglect of that person to submit to or seek proper medical or surgical treatment, or but for the negligent or improper conduct or manner of living of that person, or of treating the harm. Unless the person so acting was guilty of a wanton or reckless disregard of that person's own health or condition. d. Death is caused by harm if the death is caused by the medical or surgical treatment of the harm, unless the treatment is grossly negligent or unless the death could not have been foreseen as a likely consequence of the treatment, and e. Death is not caused by harm unless the death takes place within a year and a day of the harm being caused. Section 65. Abatement of murder. The general provisions of Part 1 with respect to abatement are, in their application of the purposes of this chapter, subject to the special provision, namely, that where a person commands the killing of another person, knowing that the killing will be unlawful, then, although the criminal offense of the person commanded is reduced to manslaughter, or to an attempt to commit manslaughter, by the belief of being under a legal duty to obey the command, the person giving the command commits the same criminal offense as if the person commanded had not personally believed to be under legal duty to obey the command. Section 67. Medical or surgical treatment. 1. Where a person does an act in good faith, for the purposes of medical or surgical treatment, and intent to cause death shall not be presumed from the fact that the act was or appeared likely to have caused death. 2. An act which is done, in good faith and without negligence, for the purposes of medical or surgical treatment of a pregnant woman is justifiable, although it causes or is intended to cause abortion, or miscarriage, or premature delivery, or the death of the child. Chapter 3. Section 69. Causing harm. A person who intentionally and unlawfully causes harm to any other person commits a second-degree felony. Section 69A. Female circumcision. Section 69A. 1. Whoever excises, infibulates or otherwise mutilates the whole or any part of the labia minora, labia majora and the clitoris of another person commits an offense and shall be guilty of a second-degree felony and liable, on conviction, to imprisonment of not less than 3 years. 2. For the purposes of this section, excise means to remove the prepuce, the clitoris, and all or part of the labia minora. Infibulate includes excision and the additional removal of the labia majora. Section 70. Use of offensive weapon. A person who intentionally and unlawfully causes harm to any other person by the use of an offensive weapon commits a first-degree felony. Section 72. Negligently causing harm. A person who negligently and unlawfully causes harm to any other person commits a misdemeanor. Section 73. Dangerous thing, negligently causing harm or danger. A person who a. Being solely or partly in charge of a steam engine, machinery, ship, boat, or dangerous thing, or matter of any kind, or b. c. Having undertaken or being engaged in medical or surgical treatment of a person, or having undertaken or being engaged in the dispensing, supplying, selling, administering, or giving away of a medicine or a poisonous or dangerous matter. Negligently endangers the life of any other person, commits a misdemeanor. Section 74. Threat of harm. A person who threatens any other person with unlawful harm, with intent to put that person in fear of unlawful harm, commits a misdemeanor. Section 75. Threat of death. A person who threatens any other person with death, with intent to put that person in fear of death, commits a second-degree felony. Section 76. Definition of unlawful harm. Harm is unlawful which is intentionally or negligently caused without any of the justifications mentioned in Chapter 1 of this part. Section 77. Explanation as to causing harm by omission. A person causes harm by an omission, within the meaning of this act, if harm is caused by that person's omission to perform a duty for preventing harm as mentioned in Section 78, and not in any other case. Section 78. Duty to prevent harm to another person. A person is under a duty for preventing harm to another person. A. If the first mentioned person is under a duty, as mentioned in Section 79, to supply a person with the necessaries of health and life, or B. If the first mentioned person is otherwise under a duty, by virtue of an enactment, or by virtue of an office or employment, or by virtue of a lawful order of a court or person, or by virtue of an agreement or undertaking, to do an act for the purpose of averting harm from a person, whether ascertained or unascertained. Section 79. Duty to give access to the necessaries of health and life. 1. Where there is a duty to give access to the necessaries of health and life. A. A spouse is under a duty to give access to the necessaries of health and life to the other spouse who is actually under the control of that spouse. B. A parent is under a duty to give access to the necessaries of health and life to the parents' child actually under the control of the parent, which child is not of an age and capacity as to be able to obtain those necessaries. C. A guardian of a child is under a duty to give access to the necessaries of health and life to the child actually under the control of the guardian. 2. A woman, who is delivered of a child, A. is under a duty, so far as she is able, to summon assistance and to do any other act necessary and reasonable for preserving the child from harm by exposure, exhaustion, or otherwise by reason of its condition as a newly born child. B. Is under a duty, so far as she is able, to support and take reasonable care of the child, which is under her control or in her care or charge, until it can safely be weaned. 3. A person who, by virtue of office as a jailer, relieving officer, or otherwise, or by reason of the provisions of an enactment is bound to supply any of the necessaries of health and life to a person, is under a duty to supply them accordingly. 4. A person who wrongfully imprisons another person is under a duty to supply that other person with the necessaries of health and life. 5. A person who has agreed or undertaken to supply any of the necessaries of health and life to another person, whether the other person is a servant, an apprentice, or otherwise, is under a duty to supply them accordingly. 6. Where a person under a duty expressed in this section has not the means of discharging the duty, and there is another person or public authority bound to furnish that person with the means, that person is under a duty to take reasonable steps for obtaining the means from that other person or authority. 7. Where a person, under a duty to supply any of the necessaries of health and life to another person, lawfully charges the wife, servant of that person, or any other person with the supply of those necessaries, and furnishes the means for that purpose, the wife, servant, or other person so charged is under a duty to supply them accordingly. 8. For the purposes of this section, necessaries of health and life includes proper food, clothing, shelter, warmth, medical or surgical treatment, and any other matter which is reasonably necessary for the preservation of the health and life of a person. Section 80. Explanation as to office. 1. Where, under Section 78 or 79, a duty is constituted by an office, employment, agreement, or undertaking, the duty is sufficiently constituted in the case of a person A. who is actually discharging the duties belonging to that office or employment, or B. who is acting as if under that agreement or undertaking with respect to another person. 2. A person is not excused from liability for failure to discharge a duty within the meaning of Section 78 or 79 on the grounds that another person is also under the same duty, whether jointly or independently, and whether on the same or on a different ground. Section 81. Exceptions to causing an event. The general provisions of Part 1 with respect to causing an event are, in their application to the matters of this chapter, subject to the following explanations and modifications, namely: a. A person has not caused harm to another person by omitting to supply the other person with the necessaries of health and life, unless it is proved against the person that the other person, by reason of age or physical or mental state, or by reason of control by the accused person, could not by reasonable exertion have avoided the harm. b. The disease or disorder which a person suffers as the inward effect of grief, terror, or any other emotion is not harm caused by another person, although the grief, terror, or emotion has been caused by that other person whether with intent to cause harm or otherwise. c. The harm which a person suffers by execution of a sentence of a court in consequences of a prosecution instituted, prosecuted, or procured, or of evidence given or procured to be given by another person, whether in good faith or not, is caused by that other person, and d. Except as in this section expressly provided, a person is not excused from liability to punishment for causing harm to another person, on the grounds that the other person, personally, by trespass, negligence, act, or omission, contributed to causing the harm. Section 82. Special provision as to medical or surgical treatment. A person who in good faith, for the purposes of medical or surgical treatment, intentionally causes harm to another person which, in the exercise of reasonable skill and care according to the circumstances of the case, is or ought to have known to be plainly improper, is liable to punishment as if the harm had been caused negligently, within the meaning of this act, and not otherwise. Chapter 4. Section 84. Assault. A person who unlawfully assaults another person commits a misdemeanor. Section 85. Different kinds of assault. 1. For the purposes of Section 84, assault includes a. Assault and battery. b. Assault without actual battery, and c. Imprisonment. 2. An assault is unlawful unless it is justified on one of the grounds mentioned in Chapter 1 of this part. Section 86. Assault and battery. 1. A person makes an assault and battery on another person, if without the other person's consent, and with the intention of causing harm, pain, or fear, or annoyance to the other person, or of exciting the other person to anger, that person forcibly touches the other person. 2. The application of subsection 1 is subject to the following provisions. a. Where the consent of the other person to be forcibly touched has been obtained by deceit, it suffices with respect to intention that the touch is intended to be a touch that is likely to cause harm or pain, or is intended to be a touch that, but for the consent obtained by the deceit, would have been likely to cause harm, pain, fear or annoyance, or to excite anger. b. Where the proper person is insensible, unconscious, or insane, or is, by reason of infancy or any other circumstance, unable to give or refuse consent, it suffices, with respect to intention. 1. That the touch is intended to cause harm, pain, fear or annoyance, or 2. That the touch is intended to be a touch that would be likely to cause harm, pain, fear, or annoyance to, or to excite the other person's anger, if that person were able to give or refuse consent, and were not consenting. c. The slightest actual touch suffices for an assault and a battery, if the intention is an intention, as is required by this section. d. A person is touched, within the meaning of this section, if the body is touched, or if the clothes or any other thing in contact with the body or with the clothes on the body are or is touched, although the body is not actually touched, and e. For the purpose of this section, with respect to intention to cause harm, pain, fear or annoyance, it is immaterial whether the intention is to cause the harm, pain, fear, or annoyance by the force or manner of the touch itself or to forcibly expose the person, or cause that person to be exposed to harm, pain, fear, or annoyance from any other cause. Section 87. Assault without actual battery. 1. A person makes an assault without actual battery on another person, if by an act apparently done. In commencement of an assault and battery, the person intentionally puts the other person in fear of an instant assault and battery. It. 2. The application of subsection 1 is subject to the following provisions. A. Is not necessary that an actual assault and battery should be intended, or that the instruments or means by which the assault and battery is apparently intended to be made should be, or should by the person using them be believed to be, of a kind or in a condition that an assault and battery could be made by means of them. B. A person can make an assault, within the meaning of this section, by moving, or causing a person, an animal, or a matter to move, towards another person, although that person or the other person, animal, or matter, is not yet within a distance from the other person that an assault and battery can be made, and c. An assault can be made on a person, within the meaning of this section, although that person can avoid actual assault and battery by retreating, or by consenting to do, or to abstain from doing, an act. Chapter 5. Section 89. Kidnapping. A person who kidnaps another person commits a second-degree felony. Section 90. Definition of kidnapping. A person commits the criminal offense of kidnapping. A. Who unlawfully imprisons any other person, and takes that other person out of the jurisdiction of the court, without the consent of the other person. B. Who unlawfully imprisons any other person within the jurisdiction of the court, in a manner that prevents the other person from applying to a court for release or from discovering to any other person the place of the imprisonment, or in a manner that prevents a person entitled to have access from discovering the place where the other person is imprisoned. Section 91. Abduction of child under 18. A person who abducts a child under 18 years of age commits a misdemeanor. Section 92. Definition of abduction. 1. A person commits the criminal offense of abduction of a child who with intent to deprive a person entitled to the possession or control of the child or with intent to cause the child to be carnally known or unnaturally carnally known by any other person. A. B. Unlawfully takes the child from the lawful possession, care or charge of a person, or detains the child and prevents the child from returning to the lawful possession, care or charge of a person. 2. The possession, control, care or charge of a child by a parent, guardian, or any other person continues although the child is absent from actual possession, control, care, or charge, if the absence is for a special purpose only, and is not intended by the parent, guardian, or the other person to exclude or determine the possession, control, care, or charge for the time being. 3. A person does not commit the criminal offense of abduction by taking or detaining a child unless that person knew, or had grounds for believing that the child was in the possession, control, care, or charge of another person. Section 93. Child stealing. A person who steals a person under 14 years of age, whether with or without consent, commits a second-degree felony. Section 94. Definition of child stealing. 1. A person steals another person if the first-mentioned person unlawfully takes or detains the other person with intent to deprive the other person of the possession or control to which any person is entitled, or with intent to steal anything on or about the body of, or with intent to cause harm to, that other person. 2. For the purposes of subsection 1, it is not necessary to prove that the person stolen had been taken from the possession, care, or charge of a person, if it is shown that some person, other than the accused person, was entitled to the control or possession of the person stolen. Chapter 6. Section 97. Rape. A person who commits rape commits a first-degree felony and is liable on conviction to a term of imprisonment of not less than 5 years and not more than 25 years. Section 98. Definition of rape. Rape is the carnal knowledge of a female of not less than 16 years without her consent. Section 99. Evidence of carnal knowledge. Where, on the trial of a person for a criminal offense punishable under this Act, it is necessary to prove carnal knowledge or unnatural carnal knowledge, the carnal knowledge or unnatural carnal knowledge is complete on proof of the least degree of penetration. Section 100. Effect of void or voidable marriage with respect to consent. Where a female is compelled to marry another person by duress as to make the marriage void or voidable, the marriage does not have effect for the purpose of Part 1 of this Act with respect to consent. Section 101. Defilement of child under 16 years of age. 1. For the purposes of this Act, defilement is the natural or unnatural carnal knowledge of a child under 16 years of age. 2. A person who naturally or unnaturally carnally knows a child under 16 years of age, whether with or without the consent of the child, commits a criminal offense and is liable on summary conviction to a term of imprisonment of not less than 7 years and not more than 25 years. Section 102. Carnal knowledge. A person who has carnal knowledge or has unnatural carnal knowledge of an idiot, imbecile or a mental patient in or under the care of a mental hospital whether with or without the consent of that other person, in circumstance which prove that the accused knew at the time of the commission of the criminal offense that the other person has a mental incapacity, commits a criminal offense and is liable on summary conviction to a term of imprisonment of not less than 5 or and not more than 25 years. Section 103. Indecent assault. 1. A person who indecently assaults another person commits a misdemeanor and is liable on conviction to a term of imprisonment of not less than 6 months. 2. A person commits the criminal offense of indecent assault if, without the consent of the other person, that person a. forcibly makes a sexual bodily contact with the other person, or b. sexually violates the body of the other person in a manner not amounting to carnal knowledge or unnatural carnal knowledge. Section 104. Unnatural carnal knowledge. 1. A person who has unnatural carnal knowledge a. of another person of not less than 16 years of age without the consent of that other person commits a first-degree felony and is liable on conviction to a term of imprisonment of not less than 5 years and not more than 25 years, or b. of another person of not less than 16 years of age with the consent of that other person commits a misdemeanor, or c. of an animal commits a misdemeanor. 2. Unnatural carnal knowledge is sexual intercourse with a person in an unnatural manner or with an animal. Section 105. Incest. 1. A male of not less than 16 years of age who has carnal knowledge of a female whom he knows is his granddaughter, daughter, sister, mother or grandmother commits a criminal offense and is liable on summary conviction to a term of imprisonment of not less than 3 years and not more than 25 years. 2. A female of not less than 16 years or age who has carnal knowledge of a male whom she knows is her grandson, son, brother, father or grandfather, commits a criminal offense and is liable on conviction to a term of imprisonment of not less than 3 years and not more than 25 years. 3. A male of not less than 16 years of age who permits a female whom he knows is his grandmother, mother, sister, or daughter to have carnal knowledge of him with his consent, commits a criminal offense and is liable on conviction to a term of imprisonment of not less than 3 years and not more than 25 years. 4. A female of not less than 16 years of age who permits a male whom she knows is her grandfather, father, brother, or son to have carnal knowledge of her with her consent, commits a criminal offense and is liable on conviction to a term of imprisonment of not less than 3 years and not more than 25 years. 5. In this section, sister includes half-sister, and brother includes half-brother, and for the purposes of this section an expression importing a relationship between two people applies although the relationship is not traced through lawful wedlock. Section 109. Compulsion of marriage. A person who by duress causes another person to marry against that other person's will, commits a misdemeanor.